Can one company hold a monopoly over life-saving medicines? Or should patients everywhere have affordable access? This very question was at the heart of the famous Novartis case in India, a landmark decision that shook the pharmaceutical world.
Before we dive into the case, let's understand patents. A patent is a legal right given to an inventor for a limited time, usually 20 years. It rewards innovation by giving the inventor exclusive rights to make, use, or sell their invention. But here's the catch: patents also create a monopoly. And in sectors like medicine, monopoly means higher prices, often putting life-saving drugs out of reach for ordinary people. In India, the Patents Act of 1970 governs patent rights, and there's one special safeguard, Section 3D. This section prevents evergreening, a practice where companies make minor tweaks to existing drugs, like changing the form or dosage, just to extend their patent life. In short, India made sure that only genuine innovations get protection, not cosmetic changes. Let's go back to Novartis' case. Novartis, the Swiss pharma giant, developed Glivec, a breakthrough drug for treating chronic myeloid leukemia and other cancers. And in 2003, Novartis applied for a patent in India on its beta-crystalline form of imatinib mesylate. But here's the issue. India argued that Glivec was just a new form of a known substance and not a truly new invention. That meant, under Section 3D, no patent. Novartis challenged this rejection, first at the Indian Patent Office, then the Madras High Court, and finally at the Supreme Court of India. The company argued that Glivec was innovative and deserved protection, but activists, patient groups, and generic manufacturers argued the opposite, that granting the patent would block cheaper generic versions, making the drug unaffordable for thousands of cancer patients in India and beyond. On April 1, 2013, the Supreme Court of India delivered its verdict in Novartis AG versus Union of India and others. The court rejected Novartis's patent claim, ruling that Glivec did not show enhanced efficacy beyond the known substance. The message was clear: India will not allow evergreening. This judgment ensured that generic manufacturers could produce affordable versions of Glivec, reducing costs by nearly 90% for patients. This landmark case set a global precedent. It showed how developing countries can balance patent protection with public health. For patients, it meant affordable access. For pharmaceutical companies, it was a reminder that innovation must be real and substantial, not just a way to extend monopoly. The Novartis case continues to shape the debate on intellectual property, healthcare, and human rights, and it asks us, should profits ever come before patients,